Hey everyone, welcome back to Pink Dino Media. We've got some major trial updates on the Collin Griffith trial, covering the last 3 days of testimony, including a key statement from Detective Peters. And today, day 4, we're expecting even more as the prosecution prepares to rest its case. So we're going to break it down real quick, and then we're going to go ahead and head into court. I am running a few minutes behind this morning. So the prosecution opened with a strong argument, painting Collin's actions as deliberate and premeditated. Nancy Jones, a neighbor, took the stand, recounting her observations of Collin and his mother, Catherine Griffith. Shortly before the tragic incident, her testimony provided insight into the relationship and any possible tensions leading up to that day. One of the most powerful testimonies came from Collin's grandfather, who revealed that Collin had previously expressed thoughts of harming his mother. He claimed Collin had specifically mentioned a desire to injure her throat. That statement is a major piece of evidence for the prosecution, pointing toward the potential of premeditation. Now, then we have day 3. Then we get into the testimony from Detective Peters, who walked the court through key evidence found during the investigation. He presented the criminals, the crime scene findings, the text messages, and online activity that gave all insight into Collin's state of mind, a timeline of events that the prosecution argues that does support their case. Detective Peters' testimony was meant to solidify motive and intent, which is crucial as the prosecution nears the end of their argument. We might get 1 or 2 final more witnesses, but after that, the prosecution is set to rest. Once that happens, the defense gets their turn to make their case. The defense is still pushing the self-defense argument, claiming that Collin had a reason to feel threatened and that Susan, I don't know. But they're already suggesting past domestic disputes between Collin and his mother. But today we'll see if they bring anything new to counter what we've heard so far. There's a lot that's been happening in this case, and things could shift as the defense starts presenting their case. I will be with you guys and give you updates as they unfold. And so far, we're going to go ahead and see what's happening in court. Also, please drop your thoughts in the comments, and let's see how it goes.
Yes. actually Mr. Hendry will be making the arguments.
We're going to do it now. Sorry, I was setting my computer up. Your Honor, this time the defense moves for a judgment of acquittal on both counts. I will work with the kidnapping charge first. The state's charge of kidnapping. First, kidnapping is a specific intent crime, which means that at the time the alleged kidnapping took place, it had to be the intent to kidnap, and typically the intent is to commit something else. So it's charged right now that the intent was to either further the commission of another felony or to harm or terrorize the victim. Now, as far as the evidence that has been presented in this trial about the kidnapping, we have essentially the two neighbor witnesses who presented any testimony whatsoever about the kidnapping. Both witnesses describe Kathy Griffith as angry. They describe her as, stomping around in the yard, throwing things into a car. The first witness described her swinging her arms around a lot, both away from Collin and as she approached Collin, and even up until she was so close that Collin could reach out and touch her. So at that moment, we have the testimony, which seems to align between both witnesses, that Collin grabbed his mother. She exclaimed, according to witness 1, "Let go, you're hurting my hair." Witness 2 did not hear anything. And then, although it has been argued that Collin dragged her into the house, the actual testimony from the witnesses was that the two went into the house. So if we pause it right there, at this point we have what is arguably a misdemeanor battery. We have what could be a defensible touch on Collin's part, that he, in response to his mother swinging his arms in his face, reached out and grabbed her. And whether or not he had the right to do so, either way, it would either be a defensible battery or a misdemeanor battery. When examined on cross-examination, neither witness said that they heard Kathy exclaim anything about not wanting to go into the house. They did not see her fighting to not go into the house. They saw her legs moving. They saw her go into the house with Collin. And that moment is what has been alleged and the only evidence that has been shown of a kidnapping. So at that point, Mr. Griffith's specific intent to kidnap has to have been completed. We do not have that in this case, Your Honor. We have not heard any evidence that there was any fight on Kathy's part, any unwillingness to go inside of that house in that moment. We know she didn't want to be touched at that time, that she said that "you're hurting me." We don't know if she was upset about him having his hands on her. We do know that he was touching her too hard, essentially, is the evidence that has come forward. And again, that would be a misdemeanor, which would not be sufficient in any case to charge a kidnapping with. So we move on from there. What evidence have we heard in this case that is going to turn this from a misdemeanor battery to a kidnapping? Well, we ultimately have a deceased person in this house. We have, the fact that she is found in the house roughly an hour and 15 minutes after this incident occurred, with the yelling outside and the touch on the upper torso. And we have no evidence of what happened inside the house. We have no evidence that Kathy was not in that house, or wasn't in that house against her will, that she remained in that house against her will, that she was not able to move in that house. The only evidence we have of anything that happened inside that house is the body itself, with the forensic evidence that has come into play from that, and Mr. Griffith's 911 call. Mr. Griffith's 911 call states that there was an extended, prolonged fight, and that they ultimately, there's the accident that she fell on the knife. There is no mention that that fight started outside of the house, that it continued inside of the house, that it continued all the way up until the moment of her death. There is no evidence that she was dragged immediately from the porch into the house and murdered at that time, like the state may offer as an alternative. We have not heard that from any witness. We have not seen that in any evidence that has been presented. So again, the evidence of the kidnapping turns back to the misdemeanor battery, that she was touched, that she exclaimed upon the touch, and that she continued into the house without doing anything else to say that she did not want to go in that house. All of the case law on kidnapping gets into whether or not that the crime itself was completed, whether it was necessary to complete the other crime if there is another crime that's charged. But all of it, every case, includes proof that the victim was held or moved against their will. And we don't have that in this case. So we are not even at the starting point of whether or not you should consider a phase-on test or anything like that that falls under the kidnapping line of cases, because we have not heard a single piece of evidence that says that Ms. Griffith did not go inside of that house willingly. So for that reason, we are asking for a judgment of acquittal on the kidnapping charge. As far as the first-degree murder goes, Your Honor, the evidence that has been presented so far of premeditation is that Mr. Griffith had a conversation with his grandfather in which he said that he wants to kill his mother, that he wants to slit her throat, according to the witness. We have the testimony from the officers who stated that he said things like he wanted to kill her. We have the testimony of Mr. Griffith himself in the back of the car where he said that he could kill her. Again, other than Mr. Walantis' testimony, every one of those officers, every piece of body cam footage, every piece of car footage that we've seen is conditional. That if violence occurs, if she comes at me again, if anything, then premeditation does not override someone's right to self-defense. If it did, then every officer who ever acted with lethal force would be charged with a capital crime. They are trained to respond to situations, and they know how to respond to that situation. That knowledge does not create premeditation. The fact that Mr. Griffith thought about what he would do in a situation where he felt that he was being threatened, and even took it as far as to how he would do it, does not create premeditation. That is not a crime. That can still fall within the realm of self-defense. The only piece of evidence that we have that would go against that is that he didn't have enough marks on his body. I mean, the state offered physical proof that he had injuries. They have argued that those injuries were insufficient in opening. We have not had any witnesses testify to the extent of Collin's injuries, what could have caused those injuries, what could not have caused those injuries. In order for this to be a first-degree murder, we have to have premeditation, which so far I do not believe the state has proven, and we have to have a waiver of self-defense in some way. If there is just a waiver of self-defense, if this was a fight that got out of control, I apologize, do you have to?
Just my school keeps calling, but I'm wondering if there's someone.
Yes, Your Honor, I understand.
Okay, I started a few minutes late, about 4 minutes, so I'm going to start fast forwarding during those times that there's nothing happening.
Okay. Your Honor, I was speaking as to the, if this were a fight that got out of control and Mr. Griffith had started that fight, then this is arguably second-degree murder, as would be charged, that this was something that was created inside of the moment, that the decision to kill did not require adequate reflection, and that this would be a second-degree murder. So we have I don't believe that the felony murder should be considered, because I don't believe that the kidnapping is sufficient to reach that, and there's been no evidence that the kidnapping was a continuous crime. Again, we have proof of her injuries showing that there was some kind of fight. We have proof of Mr. Griffith's injuries showing that there was some kind of fight. We don't have any proof that Mr. Griffith made a previous decision to kill in this moment, that this was orchestrated in any way by him. In fact, we have the opposite. We have Miss Griffith showing up at that house without permission to do so, being angry as soon as she gets there and never cooling off, according to the witnesses. At the time that she gets into his face, Mr. Griffith acts. From that moment forward, they go inside the house and it's unclear what happened. We have no evidence, we have no forensic evidence that showed what happened inside of that house to show that this was something that was planned, that this was something that was thought out, and that this matched any kind of a decision that Mr. Griffith had made. If anything, it is more likely that this fight escalated once the parties got back inside, this fight escalated, that there was at some point, someone gets a knife, and then Miss Griffith ends up dead. And to me, that is the realm of a second-degree murder. That is a standard fight that goes too far, and that is what the jury should be considering. They have not had any proof again, that would rise to the level of premeditation. They have not had any proof in this crime that anything else would enhance this crime to a first-degree murder. This is a second-degree murder and a battery that happened beforehand. And it is arguably self-defense on either issue, but again, I will concede that by raising self-defense, we have created a circumstance where the jury has to make a finding of fact. So I'm not arguing that this entire incident can't be considered by them. I'm just arguing that it should not be a kidnapping and it should not be under the felony murder statute, and it should only be a second-degree murder.
As it pertains to the kidnapping, from two independent witnesses, we saw and we heard that the defendant grabbed Kathy by the hair. He did that forcefully. And what did he do? He dragged her / pulled her in against her will as she was protesting and yelling loud enough so that one of the witnesses could specifically hear from inside, looking out the window, "Stop, Collin, you're hurting me." At which point the defendant dragged her / pulled her into the house, which was clearly forcibly, which was clearly against her will. And then once he had her inside, of course, he confined and/or abducted her from outside into inside and/or imprisoned her. The last place that she would want to be would be inside after being yanked inside by the hair by her son, who has told multiple people, obviously, his intention to kill her, when he's furious, when she had just sent him the text message regarding the other person that he murdered by shooting that person in the chest and in the head, and when she threatened to come forward and tell the officials in Oklahoma and elsewhere about the defendant confessing that it in fact was a murder, that it was not self-defense, and that he had planned it, the defendant's anger level was through the roof. So once he gets her inside, he has no prying eyes, he has no witnesses, and he can inflict anything and everything he wants to on his mom. So once she gets yanked from outside to inside, and mind you, he had her by the hair, which there's no way she could get loose from that. So as he yanks her inside, once that door closes, that was clearly the beginning of the end for her. Now he's all alone with her, with no witnesses and nobody that could help her. And his intent was to inflict bodily harm upon his mom, or to terrorize her, and/or to commit or facilitate the commission of the murder. Judge, once the defendant gets her inside, there's not going to be an hour and 15 minutes of these two people talking and having a rational conversation. It was an absolute powder keg that went off immediately. So the defendant, as we come now to the first-degree murder, you can see the pathway by which the defendant pulled her by her hair, dominated her physically. He's 6'2", outweighs her by, who knows, maybe 30 pounds or so. He's bigger, he's stronger, he's younger. He had to go to the butcher block, take out the knife of his choosing, continuing on with the premeditation, and then stab her, not just any place, not just cut her, but stab her in one of the most vulnerable parts in the human body, which was right in the neck. And as we heard from Robert Volantis, the defendant accomplished exactly what he wanted to do for so long, which was to stab her / slit her throat, watch her bleed, and watch the life drain from her, which is exactly what he was able to accomplish with premeditation. So, Judge, I would rely upon the facts and the evidence of the whole record and ask that you deny the defense's motion and allow the jury to consider both the kidnapping charge as well as the first-degree murder charge as we go forward, Your Honor.
Your Honor, as to some of the arguments just made, first off, there's been no evidence of anger in the moment on the part of Mr. Griffith. We have the evidence from the neighbor that he was calm, that Kathy was irate, that she was flailing around, and that he reached out, but that his demeanor did not rise. Like, he didn't start, there was no evidence of rage or anything like that. So I know the state keeps using those words. That's an argument on their part, but that is not the fact that has been shown in this case. As far as the decision to choose a knife, again, that's not a fact in evidence. As far as the decision to dominate her physically, well, we have evidence of bruising. So I guess I would concede that there was a physical altercation, and it looks like Ms. Griffith bore the worst of that. But I don't know that dominate physically is something that has been testified to in any way. Again, it's being argued by the state attorney. The size of Mr. Griffith that keeps coming in from the state's words, that he's 6'2", that he's some weight, we don't have any fact on Mr. Griffith's size. I mean, the jury has observations. They can see me standing next to him, and they can tell that he's much smaller than me, and I'll tell you, I'm not 6'2". So I don't think that that comes into play in a decision to, decide whether or not this was a premeditated murder. And as far as the kidnapping, again, the only evidence we have of Kathy's intent is when she shows up mad, when she's throwing things in his car. We have her intent. Yeah, And she had already gone into that house. I mean, she goes in, she comes out with stuff. That stuff was not sitting inside. So we have her not wanting to be pulled by the hair, but again, we don't have any proof that she was pulled by the hair. We have the autopsy of her body. We do not have a single shred of evidence that she was harmed in any way by a grasp to her hair. There's no bruising of her scalp. There's nothing like that that has been shown. So she said, "You're hurting me loudly enough to be heard." That's a battery. She did not say, "No, don't take me in there. I don't want to go in there. Stop." She was not dragged. I asked the witnesses specifically if her feet were going up the stairs, and they said yes, that she was moving her own legs, that she went into that house. So I understand the state's argument that they are making, but it is argument. They are not using the facts that have been shown. And the fact is that this is not a kidnapping. This is a misdemeanor battery and then a fight that happened inside, and that fight led to a death.
Taking the evidence in the light most favorable to the state, as I must, hearing on a motion for judgment of acquittal, I do find that the state has made a prima facie case as to each element of each offense, and the motion is denied. Is there anything else we need to discuss before we bring the jury?
Judge, when do you usually do a jury instruction conference?
After everyone rests.
Okay.
Was there something in particular you
No.
wanted to address now?
No.
Are we ready for the jury?
I believe so.
All right, please.
Good morning, ladies and gentlemen. I hope that you had a restful weekend. And thank you again for your service in this case. Mr. Lean,
Your Honor, the state rests.
the state having rested its case, what says the defense?
The defense calls Susan Detman to the stand.
Ms. Lehman? Second. If I hear raise your right hand before we vote.
The evidence that are confirmed that the testimony given in this case will be the truth, the whole truth, and nothing but the truth. I do.
Ms. Detman, will you please introduce yourself to the jury and spell both your first and last name?
Susan Detman. Susan is S-U-S-A-N, and Detman is T-E-T-H-M-A-N.
Ms. Detman, How are you related to Collin Griffith?
I'm his maternal grandmother.
So your daughter was Kathy Griffin?
Yes, ma'am.
Griffith, sorry.
Yes, ma'am.
Okay. So give the jury a little bit of an idea of who the other members of your family are. Who was Kathy's father?
Robert Belantes.
Were you married at some point to Robert Willantis?
Yes, we were married for 19 years.
When did you divorce?
We divorced in 1998.
After you divorced Robert Willantis, did you get remarried?
Yes, I did.
Who did you get remarried to?
Inaki Markovich.
Okay, and you might need to spell that last name for the court.
Markevitch.
Ms. Detman, who are your children from your marriage to Robert Willantis?
John Paul Belantes, Kathy Belantes Griffith, and Christy Belantes Rooney.
Did you list them in ascending order of age, youngest to oldest?
The youngest to oldest.
Yeah. Okay. Do you have another child?
Yes, I do.
Who is that?
Kevin Markovich.
And that's from your marriage to Mr. Markovich?
Yes.
Now, Kathy, obviously Collin was Kathy's son. Did she have any other children?
Yes, she had an older son. He's still alive, Christopher Ray Griffith.
How old is he?
He is 24.
I want to ask you a few questions about Robert Willantis, your ex-husband. When you divorced in 1998, who got custody of your 3 children with him?
I did.
And since 1998, has Robert Willantis been a big part of your life?
No, except for the custody battles we went through.
What about, are you aware of his relationship with any of the 3 children that you had with him?
He didn't have a relationship once. He was not granted custody of John Paul. He didn't want Kathy, considered Kathy to be damaged goods. He only sued for John Paul.
Okay, but what was his relationship like with his children after the
He didn't
divorce?
have a relationship at all until Kathy divorced and she reached out to her dad.
When did Kathy divorce her husband and the father of Collin and Christopher?
2019, if I remember correctly. It was like December of 2019 when they filed. And I think it took a couple months for the divorce to actually take place.
Now, we saw pictures of Robert Willantis on a trip with Kathy.
Yes.
Tell the jury about that trip, what you know about it.
So Kathy wanted to meet the biological, Robert's mother, the biological grandmother, because Kathy had many medical problems. So she asked me, she said, Dad said he'll take me to California to meet his mom. They live in Anaheim. The mom lived in Anaheim, California, but you'll have to pay for it. And I said, okay. I said, just please try not to do anything too expensive. And I'll see what points I can use for the hotels. And fly over there. You guys don't need to rent a car. You can use your dad's car if it can make it to California. If not, then we'll get a rental car.
So, Ms. Detman, did you in fact pay for Kathy to go on this trip with Robert Willantis?
Yes. I paid for all the food, all the hotels, Disneyland, all of that.
And when was that trip?
That was before she got Collin back.
So before 2023?
Yes.
After 2019, though?
And after COVID was over with.
Okay.
So I believe it was 2022.
Are you aware of any other trips like that that Robert took with his other 2 children?
No, he didn't really have communication with them.
All right. So I want to ask about Kathy's funeral or celebration of life. Did the family hold such a thing for Kathy?
Yes, we had a celebration of life right here at the funeral home in Lakeland.
Was she actually buried or was she cremated?
No, she was cremated. She had conveyed to me, as well as to her sister and brothers, that she never wanted to be put in the ground. She wanted to be cremated and later taken back to the ocean in Key Largo, and her ashes be put at the Jesus statue that we have under the water in Key Largo.
Has that been done?
No, we're going to do that this summer.
Where are Kathy's ashes right now?
Right now, they're at Christie's house.
Was Robert Willantis invited to the celebration of life?
No, he was not.
Why not?
Robert tends to be very disruptive. He has difficulty with truthful manners, and we just did not want to have more lies and disruption. The final time that we could say goodbye to Kathy.
I'm going to ask you some questions now that may also be difficult. In the last roughly 2 months before Kathy died, what personal medical things were you going through?
So in the last part of June, I was diagnosed with stage 3 colon cancer. I had to have part of my colon removed and an ostomy put in place.
After you were diagnosed and had your surgery, did you have a fight with Kathy over Robert Willantis?
Yes, I did. Kathy was very adamant that she wanted Robert to take care of me, that I needed to pay for his flight from New Mexico to Lakeland, get a hotel for him for 2 weeks, and get some sort of a car, and even pay for his food. And I told Kathy, I said, that's ridiculous. He hates me. I don't want to be hurt by him. Plus, has lost his nursing license. I want a real nurse that has.
Okay, hold on.
I'm not just objecting to this collateral accusations.
Ms. Stepman, as a result of you not wanting to follow Kathy's wishes as far as Robert Willantis coming here and taking care of you, did that cause a break in communication between you and Kathy?
Yes, she refused to talk to me. She blocked my phone. She told me if I came over to the house, she would have me arrested for trespassing. She said, you can contact Collin, but you can't contact me.
And that, okay, I'll move on from this. Mr. Willantis on the stand mentioned that Kathy got Collin a second phone, and that must have been what Collin used to talk with Mr. Willantis on the phone every week or every other week. Tell the jury what you know about a second phone.
The second phone, I purchased a second phone when Collin came to live with me in the January, February time period, the first time she threw him out. And I couldn't leave a kid in the double wide by himself without a phone. Plus, since I didn't
Wait, hold on. Why didn't Collin have a phone with him when he went to live with you in January of 2024?
Because Collin and I were at the Mexican restaurant in Port Charlotte. Kathy and Collin and I were supposed to go. When I got there, Kathy said, no, I don't want to go. And I said, come on, at least have some nachos or something. No, I don't want to go. And I said, can I take Collin with me? Sure. So while we were at the Mexican restaurant, she called me and she said, don't bring Collin back. I never want to see you or Collin again.
And the phone that Collin had at that point, where was it?
It was at Kathy's house.
Okay, so you brought Collin to
The double wide in Auburndale, and I didn't even have internet because, of course, I wasn't there all the time. So if I needed to, I'd hotspot my computer. I didn't want an extra expense for internet or cable or any of that. And so I realized I couldn't leave Collin here without a phone. So I told him, I said, we're going to have to go to AT&T and get a phone for you. And I even got a 786 area code because that's the area code that I have in the keys.
And that second phone, did Collin have possession of it from January of 2024 all the way up until September of 2024?
No. He only had possession of it for that small amount of time from when he came to, which would have been, it was either the end of January, the beginning of February. He had possession of it there, and then when he left, he took it, and I immediately got it like that weekend.
Okay, I'm actually going to show you what's been marked as defense exhibit number 16 and see if you recognize it. you if you recognize those messages from January of 2020.
Well,
Do you recognize those?
according to
No,
this.
no,
Okay.
don't read it. Do you recognize those messages in
No.
between you and Kathy?
No.
Okay. Do you remember there being a period in January of 2024 where where Collin was with you for several weeks and Kathy didn't remember that he had gone with you?
Yes.
And do you know what was going on with Kathy at that time?
She was suicidal, taking pills. She just didn't want to have her life. She was drinking
Okay.
excessively. She drank Everclear as her alcohol of choice.
Okay, Ms. Detman, just answer the questions, okay?
Yes.
You mentioned that she was suicidal in January. I'm going to show you what's been marked as Defense Exhibit 15. See if you recognize the subject matter of those texts.
Yes.
Judge would like to admit Defense Exhibit number 15 into evidence.
Objection.
No objection, Judge.
And receive.
Ms. Detman, Defense Exhibit 16 stated February 5th of 2024, and the blue text at the top, was Kathy's number 941-258-0963?
Yes.
And were you the number below that?
Yes, ma'am.
Okay. And you mentioned the 786 number, but you had two phones, correct?
Yes.
Why did you have two phones?
I used one for work and one for personal.
So the blue message on top talks about Kathy just having been released from the ER for an accidental overdose. Was that one of the times that she had had a suicide attempt?
Yes.
So the phone that you bought for Collin in either January or February of 2024, and I'm sorry if you already answered this, but he didn't keep that after the brief period that he lived with you then, did he?
He went home with it and I had it back on the weekend.
Okay, so shortly after he went back home to Kathy.
Yes.
So Kathy, it sounds like off and on had estrangement from various family members.
Yes.
You mentioned that you and she didn't speak for quite some time after your cancer diagnosis. Had she cut other members of the family off at other times in her life?
Her and John Paul were not speaking.
Do you know why?
Yes. She got mad at his wife because the house wasn't clean to her standard. And she said, I'm going to call DHS, which in our state is Child Protective Services, that Isabella was not taken care of, that she was in danger, something. I know DHS ended coming up to John Molantes' house. Of course, the investigation proved that there wasn't a problem, and John just said, I will never have anything to do with her again. She crossed the line.
Any other family estrangements from Kathy besides you and her brother John?
So Kevin and Kathy were supposed to go to Washington DC together.
Kevin is your son with,
Yes, and Kevin
Inaki.
and Kathy were pretty close. They were supposed to go to Washington DC together because Kevin was in officer basic training in Virginia for the Florida National Guard. He just graduated from college, and he had time off during the 4th of July. And Kathy said, you know, it'd be great if Collin and I could meet up with Jean Paul in Washington DC.
do you mean Kevin or?
Kevin, I'm sorry, Kevin would meet up. I was supposed to go because, of course, my cancer, I
Okay.
couldn't.
Miss Volantis, I'm sorry. I know you're nervous, but the estrangement, how
Yes.
that
So what
occurred.
happened is Kathy contacted Kevin and said, unless you help me get your father arrested, meaning Inaki Markovich, I don't want you coming to Washington DC with me.
Do you know what Kathy was referring to as far as helping her get your husband arrested?
Yes, they had had an altercation in our farm in Arcadia during COVID, so it was during 2020, around Easter time, it was before Easter, and she threatened him with a baseball bat, and she said she was going to get her gun and shoot him, and my husband brought a shotgun out and said, I have a shotgun here. We're not going to be doing this. And later, she said that he used the shotgun, fired the shotgun. And I said, it was a double wide. I think I would know if a shotgun had been fired in the ceiling in a double wide.
Okay. So after that interaction between Kathy and Kevin, were they estranged from each other for a while? But it sounds like she would kind of change her mind about who she was close with or wanted to have communication with. Is that?
Yes, because she called Kevin the next day and said, I'm sorry, come on to Washington DC with us. And Kevin said, I already told my cadre, my leave's been canceled.
Okay. Are you aware of threats that Kathy had made to commit suicide?
Yes.
How many are you aware of, if you know?
Aware of 5,
Okay.
no, 6.
I'm going to show you what's been marked as Defense Exhibit 14. See if you recognize this.
Yes, I do.
I'd like to admit Defense Exhibit 14 into evidence, please.
Objection,
No objection, Judge.
be received.
What is this exhibit?
I wasn't sure if Kathy showed that to me. I wasn't sure if it was blood or a magic marker because I didn't see it physically. She said that it had something to do with a song she was listening to. And she was upset because of the divorce.
And you can't quite see it now, but did you see a video of, so you can see the triangle for play. Had you seen the actual video of this?
Yes.
In it, can you see what's written on the left side of Kathy's arm? I mean, you can't see it right now, but do you remember what it said?
I don't remember what it said because it was just so horrific that, that she was doing this to herself.
I'm coming up here so I don't forget to give it to the clerk. Have you actually called law enforcement on occasion when Kathy made suicidal statements to you?
Yes,
All right, so you said you know of about 6 threats. What about actual attempts by Kathy to kill herself? Or was that the 6 and I misunderstood?
those were the 6 attempts.
Okay. Can you describe some of those for the jury?
Yes. So the first one was, well, she was still married, and she was very upset, and she had overdosed on her trazamine. And she told me, I was in Key Largo, and she lived in Key Largo at the time. And I said, I'm going to have to take you in right now to emergency room. You're going to die. And she said, no, I'm not going
Okay.
in.
Ms. Detman, it's okay. You don't have to give all of those
Okay, I'm
details.
sorry.
That's all right. I understand. So that was one attempt. What about other attempts that you're aware of?
So the second attempt was when she was in Port Charlotte. I had to go over the fence and open the sliding glass door, and she was in her bed, all dressed in black, and with a revolver in her hand.
And had she done anything with any medications that
Yes, she
time?
had overdosed on the oxycodone.
Did she end up going to the hospital that time?
Yes.
Any other attempts that you remember?
Yes, yes. There was another attempt with oxycodone again, about 4 months later. Then there was an attempt with medication and Everclear. The second attempt, she went back to the emergency room and was admitted, vapor active. The third time, when I called Port Charlotte Police, they got there and said, she appears fine to me. If she wants to drink in her own house, that there's nothing we can do. And then the most recent time was just in August of this year, August 21st. She called me and said she had overdosed on metoprolol, her heart and blood pressure medication, because the other ones didn't work. So she said, I did that. And I said, have Collin take you to the ER. No, I don't want to go. Have Collin take you. Finally, I talked Collin into taking her to the emergency room.
So, to your knowledge, Collin was home when she overdosed and actually had to drive her to the
Yes.
emergency room
Yes.
in August of 2024.
Yes.
You mentioned that Kathy had been Baker acted. Was that more than one time?
Yes.
The jury has heard a lot about some things that Kathy claimed that were maybe not true. How would you describe Kathy's reliability or her reputation for truthfulness?
Objection, Your Honor.
Judge, can we go sidebar? Ms. Detman, I'm going to go through some individual things and ask you about them, okay? First, I'm going to approach with Defense Exhibit number 17 as it's been marked. Just read it and see if you recognize it as being a text from Kathy to you. Do you recognize?
Yes, I do.
I'd ask that Defense Exhibit number 17 be admitted into evidence.
Any objection?
No objection, Judge.
It is received.
In this text from June 27th of 2024, Kathy says that she was here and pressing charges, going to 77 Hewitt Drive. That's your address, correct?
That was the address in Auburndale.
Okay. To check on you and to pick up Inaki for charges of attempted murder and assault against you. Meaning, she's claiming that Inaki actually tried to murder you, correct?
Yes.
Is that true?
No, he's never tried to murder me.
So that's something that Kathy threatened and claimed that just simply wasn't true, right?
Exactly. Yes, yes,
Has she done that on other occasions, make things up?
yes, yes. She made up that I was diagnosed with Lynch disease, which is it's an auto-recessive disorder where people have to have, they're more prone to cancer. So she said that her insurance company was forcing her to have a hysterectomy because of that. She also told Christy, and Christy was so distraught.
Okay, Ms. Detman,
I'm
I'm
sorry.
sorry. No, it's okay. I understand. So she made up that you had a disease that you do not in fact have.
No, I verified with my oncologist that I didn't have.
She also made up that John Paul Volantis had been neglecting his child, right?
Yes,
Has she ever made anything up about Robert Volantis?
yes.
What did she make up about Robert Volantis?
When she was younger, she said that Robert raped her.
And how do you know that that's not true?
It went to court, so I don't know. I only.
Did she ever tell you that she had made it up?
Oh, yes. Later, as an adult, she told me she had made that up.
Did she say why she made it up?
Yes, because she was mad at the situation between Robert and I.
Okay. Has she ever made anything up about her being responsible for everybody else's successes in the family?
Yes, she went as far to say that no one in the family would have any of their degrees, and that she, in fact, the only reason that I got my doctorate was because of her.
Okay. And did she actually make a threat to you regarding this
Yes,
belief
she
she
did.
had?
She said she was going to, when she was mad at me one time, she said she was going to contact the university where I work at, and I said, go right ahead. No, I had to.
What did she tell you she was going to
She said
say
she's
to
going
them?
to call the university, my dean, and tell him that she did all of my coursework and that I didn't do anything and that I was a phony.
Did she make up at any time that you're aware of that Collin was failing school?
Yes, she said that he had been failing school and that when he was staying at my house, that it was my fault because I wasn't observing him on the computer to make sure he was doing his work.
Was Collin ever failing to your knowledge?
No,
When did Collin graduate from high school?
he graduated last June.
Was that actually ahead of schedule?
Yes, that was a year ahead of schedule.
And did he, in addition to graduating early, did he ever, did he get college credit?
Yes.
At the same time.
He was dually enrolled in college.
You mentioned earlier that you had paid for some trips, the trip for Kathy to go visit Robert Willantis and meet his mother. Did you pay for other trips for Kathy?
Yes, the cruises that they went on, I paid for.
And the other trips that the jury has seen pictures of Kathy and Collin, who paid for all of those trips?
I did.
Did you also have, you mentioned points and using points for things.
That's our DVC, our Disney Vacation Club, as well as I have points through Hilton Honors.
Have you ever witnessed Kathy not being able to control her temper?
Yes,
Can you describe some of those
yes.
times?
She went at,
Your Honor, if we may approach for a moment. Another sidebar, the headset that Mr. Griffith is using is on mute somehow. I can't figure out how to unmute it.
Does it not have a,
It doesn't appear to have any buttons on it at all, but I may not just know how it works.
we're certain that it's plugged in?
It indicates that it's on mute. It has like a little, that's the one I've been using.
members of the jury, I'm going to ask that you step into the jury room for just a few moments while I discuss the matter with the lawyers. We'll be with you as soon as we
All rise, please.
There's two separate things. There's specific instances and reputation. Specific instances need to be known to the defendant as far as I read the instructions. As for reputation, there are two instructions, one when the reputation is known and one when it's not, but it's offered to prove that the alleged victim acted in conformity with that reputation, which is, I need you to talk me through how you're doing that, or are you not using that?
No, I think it is relevant because the defense is that Kathy grabbed the knife in the house in Auburndale, and that fits with past instances where she pulled a gun on Collin, where she attacked Inaki with a baseball bat and said she was going to get a gun, where she pinned her then husband against the house with a car, that she stabbed her husband and burned him, and those were in front of Collin, and she has independent knowledge of those too. So those are the specific instances.
Judge, I have nothing further to elaborate on besides my objection in the hallway and I object to anything that will be contrary to what Your Honor just read in the jury instructions, Your Honor. It might be I don't know, it might be a question by question journey to see what, if anything, is admissible or relevant based upon the application of the question asked by Ms. Thornhill, the jury instruction differentiating between, as Your Honor pointed out, the reputation or things that the defendant has to have been present for, have personal knowledge of, and Ms. Detman, depending on how narrow, or maybe I should say how wide her answers are going to be.
As far as her reputation, it's my understanding that her reputation within the family was for being dangerous and violent, and people were scared of what she might do at any given moment. So I was going to ask about both.
While I understand the community for purposes of this type of reputation evidence may be narrower, you're still going to need to lay that predicate.
Sure.
This is a family of estrangement after all, it seems.
Because of her violence.
Well,
yeah.
but I don't know who's estranged from who else. So,
Well, and it,
she needs to understand and know that family community.
okay.
So,
And even if somebody's not still a part of that community on this particular day, I mean, they don't.
I'm not suggesting it has to be at some
Okay.
particular instant in time, but I haven't heard a lot about her closeness with others who may share that in that reputation, or have knowledge of that reputation.
Okay. I will do my best. Is
And
this
we'll
our-
just take it question by question, as Mr. Levine suggests.
Okay.
Do you want to go ahead and just take our mid-morning recess?
That's what I was going to ask, if I could run fast.
Mr. Levine?
Yeah, that's fine, Judge.
All right, we'll take 10 minutes.
A lot of times he needs like a shock. Good.
It's fine as long as.
Are y'all still discussing this stuff?
But she's still on the stand. We can't really talk.
I just can't imagine it was never.
We're back on the record. Defendant is present with both lawyers, state counsel is present. Are we ready for the jury?
Yes, sir.
All right.
All rise, please.
Please be seated.
Ms. Detman, I'm going to ask you about some specific instances and may ask you to describe a little bit about them. So starting with, are you aware of Kathy having pinned her then husband to the wall of the house with her running car?
Yes, ma'am, I know.
Okay. And were you present for that?
No.
Have you ever, are you aware if Collin was aware of that incident?
Yes.
He was aware.
Yes.
What about an incident where Kathy stabbed her then husband with a corkscrew and then burned him with a terrarium light? Are you aware of that incident?
Yes, ma'am.
And are you aware that Collin was present for that incident?
Yes, ma'am.
Are you aware of Kathy threatening to kill her then ex-husband's girlfriend's family in Homestead?
Yes, I am.
Are you aware that she actually started driving toward their house to follow through on her plan?
Yes.
Did you actually speak with her on the phone then?
Yes. I was telling her that what she was doing was crazy. She was going to get in trouble, that she couldn't take it out on 3 innocent lives in Homestead. She needed to turn around and go back home.
Are you aware if Collin was aware of that incident?
I'm not aware.
The incident where you said Kathy attacked your husband with a baseball bat.
Yes,
Are you aware if Collin was aware of that incident?
I'm not aware of that.
And have you ever personally witnessed Kathy engage in a physical act of violence towards Collin?
I know that there was a fight at the house in Port Charlotte, and the fight started because she was beating him with a belt and making him do push-ups, sit-ups, push-ups, and then holding a weight above his head while he was running in place.
Okay. When you say that she beat him with a belt, were you actually there for
Yes, I
that?
was, and I tried to stop it.
Right. What about, are you aware that Kathy pulled a gun on Collin?
Yes, and then later she said that originally she denied it, then she said yes. She pulled out the gun and handed it to Collin and said, just kill me, shoot me.
So she actually admitted that to
Yes.
you.
Yes,
And obviously Collin was aware of that because he was the one who was present with her.
yes, and Corporal Rendos was aware of that also.
How was Corporal Rentus aware of this?
Because he and I and Kathy were talking about that. There's a difference when you take a gun out and give it to somebody and say, here, kill me with this, versus somebody pulling a gun out and putting it to their head or to their chest.
And so Corporal Rentus was a part of this conversation where Kathy admitted she pulled a gun,
Yes.
and she said she handed it to Collin.
Yes.
Did she ever admit that she actually threatened to kill Collin with it?
No, she never did.
Within your family, you've talked about some of the family members. Despite some of the estrangements that Kathy had, would the family sort of maybe not talk to her for a while and then everybody would come back together, take trips together? I mean,
I was the constant in her life. My oldest daughter didn't talk with her while she was married.
okay, what I'm asking about is, did the family talk about Kathy with each other?
Yes.
Okay. And whether or not Kathy was estranged from anyone at any one particular moment, did the family continue to have discussions about Kathy?
Yes.
And was there, did Kathy have a reputation within your family as being violent?
Yes.
Did she have a reputation as being unpredictable
Yes.
and volatile?
Yes.
Despite all of this, did you still love Kathy?
Yes, very much, very much. I always wanted to help her.
It appears that Kathy at times wanted Collin with her at all costs, and then at other times wanted nothing to do with him.
Yes, when she had Collin back for about a month, she spoke with me and she said, Mom, I have to get up every morning at 6 o'clock, take him to school, and then I have to go back and pick him up. And I said, you don't have to, let him ride the bus.
Okay. I'm going to show you what's been marked as Defense Exhibit 26 for identification.
Sorry, what number is that?
26. When you read this and see if you recognize it as a text from Kathy.
Yes.
I'd ask that defense exhibit number 26 be admitted into evidence.
Any objection?
No objection, Your Honor.
Be received.
In this particular text, is Kathy saying she's done with this, and she can't take Collin to school anymore?
Yes.
So that was a specific example of what you just described to the jury.
Yes.
As part of this vacillating back and forth that Kathy seemed to have about whether she wanted to have Collin live with her or didn't want Collin to live with her, did you all agree eventually to a concurrent custody plan?
Yes, we did.
And that was something, did anybody force Kathy to sign those papers?
No, not at all. Not at all.
Were there times when Kathy wanted to cancel the 751 plan, the concurrent custody plan?
Yes.
And then would she change her mind back?
Yes.
Okay, so it's safe to say she wasn't consistent.
She was not consistent.
Obviously, Kathy owned a gun, right?
Yes.
Okay. So at some point, did Kathy give her gun to you to have it out of the home in Fort Charlotte?
Yes.
Do you remember when that was?
Yes, it it's right after the incident where Officer Rentis and Lacey got involved when Collin came back to the home. So that must have been somewhere in the October timeframe of 2023.
Okay. How long did you have the gun at your home and away from Kathy and Collin's house in Port Charlotte?
Less than a week.
Okay, why did you have it for less than a week?
Because she demanded that I give it back. She said, "It's my gun, you can't have it." And I said, "But we discussed with Officer Rentis and Lacey that I would keep it." "No, it's my gun, you can't have it, and how do I know Nikki won't use it to kill you?"
Okay. So Kathy got the gun back, and
Yes.
so far as you know, she had it with her.
She had told me that she had given it to her next door neighbor Melanie for safekeeping, and then a couple months later she said, "No, Mom, I lied to you. I've had it all along."
Okay. Finally, you had a lot of communication with Kathy on September 7th and September 8th,
Yes.
right? You also had communication with Collin during that time.
Yes.
Did you allow Collin to go to your house in Auburndale when Kathy kicked him out?
Yes.
And why did you allow that?
Because a child can't be just roaming around the street by himself. Collin told me he didn't have gas in his car. You know, he had like half a tank, that was it. He didn't have his phone. He was using his computer somehow to talk with me. I told him, I said, "You have to get to Auburndale before dark because otherwise the gates will be closed. During the day, the gates are open. And go in through the back sliding glass door because you know there's no lock on the back sliding glass door. And I will be there Sunday. Don't talk to anybody and don't leave the house.
At some point, obviously, Kathy, as the jury's heard on some videos, was trying to find out if Collin was actually at your house.
Yes.
When did she finally discover that he was at your house?
I let her know around 11 that night.
On the 7th, so
Yes.
Saturday the 7th? And how did she react?
She said, "You lied to me." And I said, "I told you I didn't know if Collin was there." I said, "Because I don't want you going over there and grabbing him. You just threw him out. Give him some time, give you some time. Let's not have a huge problem associated with this."
And aside from conversations that the jury has heard between you and Kathy over the next hours, did you specifically tell Kathy not to go to your house in Auburndale?
Yes, yes. I said, "I will be going Sunday morning." I left first thing Sunday morning. I was going to leave right then, but I was so tired and I have difficulty seeing in the dark that I thought, no, it's better that I wait. You know, in hindsight, I should have gone. But, so I waited, I talked to her, she said, "No, Mom, I'm going." And that's when she said, "I've sold the car, they're gonna come by and pick it up." I said, "You can't sell Collin's car, it's his car." "No, I don't care, I'm selling it. I'm turning it into his probation officer for not, because he's not allowed to leave the county." Which when I talked to the probation officer, I found out that Kathy had told them that I had terminal cancer, so therefore Collin could come and visit me anytime I want. I had to tell the probation officer, "Well, right now, I'm only at stage 3, so no, you know, and I'm only in observation, so I'm not terminal."
Okay.
So,
But you personally told Kathy, do not go to Auburndale?
yes, I told her, I said, when I get back, I will give him gas money and I will follow him there, or we can wait until Monday morning. Let's just wait. Don't go there. You don't
Why-
have permission to go.
Why did you not want her to go to your house in Auburndale?
Because I didn't want her to start a fight with Collin. I was afraid that she would be combative, maybe go after him with a baseball bat, a gun, something.
I don't have any other questions, I don't think.
Thank you.
I don't have any other questions, but Mr. Levine does.
Mr. Levine?
Thank you, Your Honor.
Good morning, Ms. Stedman.
Good morning, sir.
Ms. Stedman, I know you're going through a lot with the loss of your daughter and cancer and everything else, but I'm going to need to ask you some questions if that's all right with you.
Yes, sir.
Now, today here in court in front of the jury, you've talked about that you were concerned that Kathy was going to attack your grandson, and then you listed a bunch of different weapons. But weren't you more concerned that your grandson, who had killed someone before and had been violent countless times with your daughter, weren't you concerned that he was the one that was going to attack your daughter?
No, he had not been violent countless times with Kathy. Kathy had been violent with him countless times.
Now, a lot of the things you've said here today, you never bothered to tell me or law enforcement or anyone.
Objection, Judge, it's improper impeachment.
Sustained.
Ms. Detman, as it pertains to your grandson, do you talk to him a lot on the phone since he's been in jail?
Yes.
Okay. Do you do any emailing with him?
I don't email with him while he's in jail.
You-
No,
you
just
prefer
talking
to-
on the phone.
Talk with him? All right.
Yes.
And how many times a week would you say that talk to your grandson on the
I
phone?
usually talk to him 3 times. I encourage him to pray. I ask him if he's eating. I mean, I'm a dietitian, that's what I do. That he's drinking his milk, that he's exercising in his cell, and most important, that he's reading books. And I keep telling him, you have got to pray. You've got to read your Bible.
Now, I mean, this is an obvious question, but you love your grandson, correct?
Yes,
Your daughter is dead, clearly,
yes.
and she's not coming back, correct?
No,
Now, would you agree that you don't want to see the defendant have to go to prison for a very long time? Is that correct?
I don't want to see my grandson go to prison for something he didn't do.
All right, well, you couldn't make it any more crystal clear that you're up there and all your answers that you've given have been driven by you believing that the defendant, your grandson, didn't murder your daughter, correct?
I am giving clear answers, sir, as to what happened. I know my daughter. That's why I didn't want her coming that day to the house without me being there. I wanted her to wait the next day so that maybe she could calm down a little bit.
Oh, you know your grandson too, correct?
Yes,
And you know his history, correct?
yes.
Now, you say you know what happened, but you weren't there when it happened.
No, I'm not saying that I know what happened. I know the possibility of what could have happened. I wasn't there, so I have no way of knowing. I just know the facts about Kathy, having lived with her and worked with her, even to try to maintain her sanity, to try to maintain that she could keep her job as a teacher, to try to maintain that she wasn't trying to slice herself and kill herself,
Okay,
and
let's-
not coming after my husband with a gun.
Okay, let's talk a little bit more about Kathy. Now, it sounded like she had some mental problems. Is that correct?
Yes,
Now, you would probably agree that it didn't help that she got impregnated when she was just a child, correct?
she was 13. She got impregnated when she ran away from the Hope House, and they found her in the hotel with her boyfriend. It didn't help that her father called her F bitches and that she was damaged goods, and he didn't want anything to do with her.
Ma'am, it sounds like you're really quick to try to throw dirt on your dead daughter. Would you agree with that?
No, not at all. My dead daughter did the best that she could. We have a problem in this country with addressing mental health. We all know that. And that's what she had. She had mental health issues. At times, she was the greatest person on the world.
All
Very
right.
intelligent.
I appreciate that, ma'am. I appreciate that. Now, your daughter worked as a teacher for many, many years, correct?
Yes, she did.
And her students loved her, correct?
Yes, they did, for the most part. I mean, as with any teachers, you're going to have some students that, I mean, I'm an educator myself. You're going to have some students that don't. For the most part, yes.
And she cared about her students, correct?
Yes, she did.
She had a passion and a love for teaching.
Yes, she did.
And she taught, predominantly she taught English, correct?
Yes.
And she cared so much about her students that at a certain point, she let one of her students move in when she was married to her ex-husband, Chuck, correct?
Yes.
And then, unfortunately for your daughter, Chuck took advantage of this underage student, is what is believed to have happened, correct? And
Judge, I'm going to object to the relevance of all this.
Approach.
Ms. Dittman, I'm sorry we have to talk about some unpleasant things, but it'll be over soon enough.
Thank you, sir.
No problem. So, do you recall my last question?
Yes.
Uh,
You were asking me why I was spilling dirt on my dead daughter, and I said I'm not. I said I supported her. I've gone into massive debt in trying to ensure
Okay, ma'am.
that she
I
had.
appreciate that, but that was a few questions.
Oh, you're talking about how Kathy ran away from the Hope House and they found her in the.
No, I'm not talking about that either, but if you listen to my questions,
Just ask the question.
it'll get easier. So, we were talking about your daughter, that she was a very committed teacher and very committed to the youth of her classroom. And I mentioned that at a certain point, she even allowed one of her students to move into the household, and it was believed that Chuck had an inappropriate relationship with this student. Are you aware of that? With a yes or no answer, if we can start at that place, I'd appreciate it. Are you aware of that?
Yes.
And you were not a big fan of Chuck as it ended up being the divorce, correct? For how he treated her, from how he impregnated her as a child through the years, being physically, emotionally, and mentally abusive to your daughter. I can't imagine you were a fan of that, were you?
No, Robert was the one that was a fan of Chuck.
Now, ma'am, I understand that you hate your ex-husband.
I don't hate him.
Well, it sounds like you're throwing stuff about Robert in a lot.
You just asked me if I was a fan, and I wanted to tell you who in the family was. I knew Chuck from the
Your Honor.
time he was.
Ms. Detman,
Oh, I'm sorry.
that's the point. He gets to ask the
I'm
questions
sorry.
to elicit the information he's looking for. If additional information is needed, Ms. Thornhill or Mr. Hendry will make sure to address it. So just pay close attention to the question that's asked and try to answer just the question that's asked.
I apologize.
That's all right. Mr. Levine?
Appreciate it. Ms. Detman, as it pertains to your last piece of information that you provided, as it pertains to your husband, he hated Chuck for what Chuck did to his daughter, that being impregnating a little girl, correct?
I'm not object to the relevance of, and to speculation about what Robert thought about Chuck.
Sustained as to relevance.
All right, Ms. Detman, if I ask you a question that, for your information, just please answer it, irrespective of your feelings about your ex-husband, all right? Now, at a certain point, Kathy got divorced from Chuck, correct?
Yes, sir.
After years of unthinkable abuse, correct?
Yes.
Now, let's move on to a different subject matter. When your grandson lived in Oklahoma with his dad for about 3 years or so, at the end of that, your grandson wanted to come live with Kathy and actually was able to, correct?
Yes.
And Kathy was very happy about that, correct?
Yes.
And she felt that she had missed out, understandably so, on multiple years of her son's life, correct?
Yes.
And she was trying to fix or make your grandson's life better.
She was trying to improve his lifestyle, yes.
Now, you mentioned you described it as a fight in Port Charlotte where law enforcement came because you said your daughter was beating Collin with a belt and made him do sit-ups and push-ups. You remember that?
I did push-ups, and I took away the sit-ups. It was push-ups and putting the weights above his head and running in place.
Okay, thanks for clarifying that. Now, you remember talking to law enforcement when they came out there, correct?
Yes.
And giving a sworn statement because you just wanted both parties, your grandson and your daughter, you wanted everybody to be safe and healthy and happy, correct?
Yes.
Now, Ms. Detman, as to the root of what the issue was that night, do Do you remember telling the deputy that the three of you were at the dining room table and Susan had Collin seated down and Kathy told Collin that she would be implementing new parenting rules and Collin would be having his Xbox, his cell phone, and other items taken away as disciplinary action due to him being disrespectful to her? Do you recall telling law enforcement that?
I remember telling law enforcement about the Xbox would be, I don't know if it was taken away, but it was going to be restricted.
And at that time, your grandson didn't want to hear from his mom, and so he stood up and threatened to fight her and said, let's just do it, correct?
That was after the incident with the exercising and belt, the beating of the belt. That's when Kathy wanted us to all sit down and eat sandwiches. Like, it literally went from one extreme to another. Sit down and eat sandwiches. And then Collin got up from the table and said, let's just do it. And I went to go get my phone to contact Officer Rentis or Corporal Rentis or Officer Lacey.
Okay, all right, very good. Now, you mentioned that you and your family members love to talk about how violent Kathy was. Is that right?
No, we didn't love to talk about how violent Kathy was. We talked about what we could do to help her. We didn't want her to lose her job. We didn't want her to be suicidal. And more than anything, we wanted her to try to get better.
Did you talk about how violent your grandson was?
No.
And why not? Weren't you concerned about that?
Objections.
Sustained.
Now, you were concerned about where the defendant would live, correct? In terms of who he might hurt, whether he lived with you and your husband, Nikki, or if he lived with Kathy.
My husband did not want Collin to live with us because he said that if Collin lived with us, Kathy would be over at the house and he didn't want to have to deal with Kathy.
Ma'am, didn't Nikki say he didn't want Kathy, he didn't want Collin to live with them because he was afraid that Collin might kill you or kill him?
No.
All right, now let's move on to the subject matter of kitchen knives or butcher knives. Do you tell the jury about the time when you noticed that there was a knife missing from your residence there in Auburndale, and you were trying to figure out who stole the knife or who took the knife?
Yes, there was a small knife with a blade like this that I bought in at the dollar store, which is now like the $1.29 store, and it had a protective cover on it, and it wasn't in the drawer with the rest of the knives and silverware.
And did you find out eventually that your grandson had taken the knife?
Yes.
And he basically told you he just needed it just in case and did not elaborate on what he was going to do with it?
He said he just needed it.
Now, at that time also, Kathy made it explicitly clear to you that she was afraid that the defendant might hurt her, correct?
Not at that time, it was later.
And there was multiple times when Kathy let you know that she was afraid for your safety and for her own safety.
Yes.
Now, you mentioned that a couple of things about the 7th and the 8th of September. You mentioned that Collin told you that he didn't have a phone with him on the 7th. Is that correct?
Yes.
Were you aware that he did have his cell phone with him and it was in his car?
So his cell phone had been turned off by his mother. She used to do that anytime she'd kick him out, she'd turn the cell phone off. In fact, it's in the records that she turned it off, and she turned it on, and she turned it off.
And you mentioned that the sliding door that it had no lock on. Is that correct?
We had adapted the sliding door for a doggy door so Freddie could go in and out when he was staying in Auburndale, my basset hound. And so we did not have a locking mechanism. You could close the door, but you couldn't lock it.
And so that's how you mentioned that your grandson was able to get into your house on the 7th?
Oh, plus the front door was, I don't believe in locks. I've been burglarized and the burglars got in quicker than I could find my lock. I don't lock things.
Okay. Now, your response when this was going on, when law enforcement made contact with you, was that you didn't know that Collin was a psychopathic killer, correct?
I never said that. Never.
If I may approach, please, Your Honor.
Amen.
And I'm going to show you page 59 of 67 of your statement on September 8th.
Let's see it before you approach.
I'm sorry?
I wanted you to see what he's
Thank you.
referring to before you approach.
And if you could just take your time and read the highlighted portion to yourself.
For one thing, I don't use words like stupid, Colin. I would never say that.
Oh,
He
ma'am.
just wants you to
Oh,
read it to
okay.
yourself.
Oh, I'm sorry. I'm sorry.
That's all right, that's all right.
We may need to go sidebar real quick.
Have you finished reading it?
Yes, uh-huh.
Approach sidebar, please.
Thank you, Your Honor.
Ms. Detman, we're almost done, all right?
Thank you.
You're welcome. Ms. Detman, is it a fair statement that Kathy had expressed to you that she was getting very frustrated with the fact that your grandson wouldn't do his chores, was disrespectful, and was basically just taking his mom for granted?
Yes.
And when Kathy was communicating with you on September 7th and September 8th, that was the Saturday and the Sunday, she did so by both text messages as well as phone calls, correct?
Yes, sir.
And Kathy made it clear that she wanted your grandson home by 10 a.m. on Sunday, correct?
Yes, sir.
And then when that didn't happen, when 10 a.m. came and went, she still made it clear that she wanted your grandson to come home, correct?
Yes.
And Kathy mentioned that she wanted him home. She wanted him to go get work at Domino's from like 4 or 4:30 to 8 or 8:30 on Sunday, correct?
Yes.
And your grandson was working at Domino's, correct?
Yes, he was.
And so Kathy wanted him home so he could then go to Domino's that night, correct?
Yes.
And then kind of towards the end of the communications, then Kathy told you she was going to your house to get Collin to come home, correct?
Yes.
And she told you that either he could go home with her or he could drive, basically follow her in his car, correct?
Yes.
All right. Thank you for your time today, Ms. Dedman.
You were at
I have no regret.
the witness release.
Yes, sir.
Mr. Levine, is she released?
Yes, sir.
Thank you.
Thank you.
Any other witnesses or other evidence you wish to present?
No, sir.
You rest. Will there be any rebuttal, Mr. Levine?
No, Your Honor.
Ladies and gentlemen, both parties have rested their cases. The next phase would be closing arguments, followed by your instructions on the law and then deliberations. Closing arguments in these types of cases are typically not short. Also, I need to have a conference with the lawyers regarding the jury instructions, although it is up to me to decide what laws apply and how you should be instructed. They do have a right to give input. That conference could take some time. So if we did all of that in closing arguments, we would be sending you out probably mid to late afternoon, and I don't want to do that to you. So I'm going to give you an early day today, and we are going to work the rest of the afternoon to get all of those strings tied up so that tomorrow morning we'll begin directly with closing arguments, and then the instructions will already be finalized, and you will be probably going to deliberations around lunchtime, I would imagine. So you're going to have an early day. Now, although you have heard all of the evidence, actually I'm not quite sure about that. Give me just a moment. Would you approach just sidebar real quick? Our schedule, ladies and gentlemen. So before I dismiss you, I just need a few minutes with the lawyers outside your presence. So if you would just wait for us in the hallway for a moment.
All right, please.
solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. I did not ask you about whether or not you wanted to give testimony in this case, so I need to talk to you about that. I assume, based on your lawyer having rested, that you did not want to testify. Is that correct?
No, Your Honor.
That's not correct, or no, you did not want to testify?
I did not want to testify, Your
All
Honor.
right. And have you talked about that with your lawyers today?
Yes,
Have you talked about it with them on more than one occasion?
several, yes.
And did they answer any questions you had about whether or not you should testify and address any concerns you had about doing one thing or the other?
Yes, Your Honor.
All right. And do you need any more time with them before you answer my question in a few minutes about whether this is your final decision? Do you need any more time with them?
Do you want to talk to me? It'll take a minute.
All right. So he can, Mr. Larson, if he can take them to the jury room.
47, 49.
Griffith, you've had just a few minutes, I assume as long as you wanted, to talk some more with your lawyers about this, correct?
Yes, Your Honor.
And did they answer any additional questions or concerns that you had?
They did, Your Honor.
You got any questions of me about your right to testify versus your right to remain silent?
No, Your Honor.
And it is your right to remain silent, and I'll be telling the jury that they're not to be concerned by that or view it as an admission of guilt. But one thing I need to make certain of is that you understand that this is your choice in this case. You understand that?
Yes, Your Honor.
There are many things your lawyers can do without your permission, things they can do that you disagree with, even things that you speak up and tell me you don't want them to do, but not this. You understand?
Yes, Your Honor.
Have they explained that to you, that no matter what they think, it's your decision?
Yes, Your Honor.
Now, they are supposed to give you some advice and counsel about what they think you should do. Are you satisfied with the advice and counsel they've given you?
I am.
And today, are you under the influence of anything, drugs, alcohol, or medicine?
No, Your Honor.
And any concerns related to competency? Have any of those arisen over the weekend, Mrs. Hornfeld?
None.
Mr. Hendry?
No, Your Honor.
And has anyone, including either of your lawyers, promised you anything or threatened you to keep you off the witness stand?
No, Your Honor.
This is your choice and your choice alone?
I know, Your Honor.
Is it?
Yes,
And you do not want to testify?
I do not.
Anything else you want on the record,
No, sir.
Mr. Hendry?
No, Your Honor.
All right. Okay, we can have the jury. I find that your choice is freely, knowingly, and intelligently made, and that it's made upon the advice of competent counsel.
And Your Honor, we're not raising additional argument on judgment of acquittal, but we would maintain our previous motion.
All right. Same rule. was saying, although you have heard all the evidence in this case, you still have not heard the arguments of the lawyers or the instructions on the law. So remember, it's not time to think about how you might decide the case or to formulate any opinions about the merits of the case. Also remember to avoid the news as I previously instructed you, and to avoid talking about the case with anyone or looking anything up. Now, tomorrow you'll be receiving this case for deliberations. I want to remind you that a jury may deliberate as much or as little as it feels necessary to that particular jury to do so. But what that means is that it's possible your deliberations could go past 5 o'clock if that's what you all agreed to. It could be earlier than that, but the point is you may want to let those who would normally be expecting you after 5 o'clock, that if you're not home, that the jury has chosen to continue deliberating. So just keep that in mind. Also, if you've been bringing your lunch during jury service, you may still do that, but I want to advise you that the court will be providing you with lunch tomorrow, because I anticipate you will begin your deliberations around lunchtime. And that way you won't have to separate, because you won't be allowed to deliberate unless you're all together at the table in the jury room. That will facilitate your deliberations beginning as soon as possible. So I hope that you enjoy the rest of your day, and we will see you tomorrow morning at 8:30.
All right.
Did you want to break before we take up jury instructions?
Whatever the court's desire.
I'm ready now.
All right. I want to make sure everyone gets a sufficient break before we start that, especially the court reporter. So we'll just take 5 minutes for a comfort break.
He's checking out that.
State. For the record, these instructions were proposed by the state. And all instructions that have been given so far will go back. We will start this morning with 2.3 stipulations. I have included the exact language from the written stipulation that you handed to me that I read in court as part of that instruction. Is there any objection to that? Mr. Levine?
No, Your Honor, thank you.
Ms. Thornhill?
No objection.
All right. That takes us to 2.7, closing argument. That appears to be standard. Is there any objection?
No, sir.
3.1, introduction to final instructions is standard. Is there any objection?
No, sir.
3.2, statement of the charge is standard and accurate. Is there any objection?
No, sir.
Seems like the substantive instructions on the crimes are at the end, that they would come next. And we begin with 7.1, introduction to homicide. That is a standard instruction and states what appear to be the appropriate lessers.
Yes, Judge, hold on, let me get to it since I didn't reorder that. It does appear to be standard and accurate.
No objection?
No objection.
All right. 7.2, first degree premeditated murder. Appears to be the standard instruction. Is there any objection?
No, sir.
7.3, first degree felony murder. Appears to be standard. Is there any objection?
No, sir.
That takes us to 7.4. Well, after that, I would give when there were lesser included crimes or attempts. That is back up. Here, and again, it states second degree murder and manslaughter as the lessers.
Those are the category 1 lessers.
Any other lessers requested?
No, sir.
All right, and then for kidnapping, false imprisonment.
Correct. Also a category 1 lesser.
Any other lessers requested as to kidnapping?
No, sir.
All right. All right, second degree murder appears to be the standard instruction. Is there any objection?
No, sir. There doesn't appear to be a manslaughter instruction in the packet.
I don't have it either. Let me pull it from the Florida Bar website. Give me just a moment. also comes before when there are lesser included
Right.
crimes or attempts. Is there any objection to the kidnapping instruction as proposed?
No, sir.
All right. So since the state did not include 7.7 manslaughter, is the state asking to proceed on just manslaughter by act, element 2A?
Yes, sir.
Do you agree with that?
I do agree with that.
All right. So it will read, to prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. Kathy Griffith is dead. Have you been putting her middle name in?
No, Your Honor.
And then I will take out the A, the letter A. Element 2 will simply read, Collin Griffith intentionally committed an act or acts that caused the death of Kathy Griffith. And then the next paragraph, every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously explained to you. In order to convict manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. And that's it, correct, Mr. Levine?
It is, and thanks for taking care of that, Judge.
Ms. Thornhill, you agree
I
that's
do.
all they should be instructed on?
I do agree.
Just a moment. That would then take us to 9.2, false imprisonment, which appears to be the standard instruction. Is there any objection?
No objection.
All right. Moving back up.
Judge, do you read excusable homicide and justifiable use of deadly force after the lessers or after introduction of homicide, or?
Well, I generally read that after all lessers,
Got it.
unless you want it someplace else.
Nope.
Mr. Levine?
I'm fine with whatever the defense requests, Your Honor.
All right. And so that would come next. And let me pull up that instruction. I had it up somewhere, I think, from this morning. Right, that is 3.6F. And this was proposed by the defense, but it's got the whole kitchen sink in, so we need to talk about that.
Yep.
Just a moment. it should, the title should just be justifiable use of deadly force, correct?
Correct.
It is a defense. You're claiming self-defense only as to count one, correct?
The first degree murder, yes.
It is a defense to the crime of first-degree murder if the actions of Collin Griffith constitute the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. Collin Griffith does not have the burden of proving that he was justified using deadly force. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt that the defendant was not justified in using deadly force. Collin Griffith was justified in using deadly force. He reasonably believed that such force was necessary to prevent imminent death or great bodily harm to himself, correct?
Correct.
And you are not requesting or the imminent commission of some applicable force?
No, because the applicable forcible felony would be aggravated battery, which indicates death or great bodily harm, so I think it's unnecessary.
All right. Is there any dispute about duty to retreat and which instruction I give on that, Mr. Levine? There's either Collin Griffith had no duty to retreat before using deadly force, or one that begins if Collin Griffith was not committing any crime other than the alleged, I assume I would say kidnapping. No. You tell me. That's not right.
I don't think he had a duty to retreat. He was in a place that he was allowed to be, in fact, was living there, so it's like it's his home.
Mr. Levine?
I don't disagree that the defendant did not have a duty to retreat. Of course, I said in the context of
I
the
understand.
defense advancing the self-defense.
I understand. All right, so we'll simply read Collin Griffith had no duty to retreat before using deadly force. Why is that second part here again? Oh, because he was in a dwelling. Ms. Thornhill, that next section is similar. To the paragraph which reads, Collin Griffith was justified in using deadly force if he reasonably believed that such force was necessary to prevent imminent death or great bodily harm to himself or others. But then this next section encompasses the same context, but or the same law, but in the context of standard of ground. I don't think both need to be given, but is this what you're requesting, or just the simple to prevent?
I mean, I would rather have both, just in case the jury thinks that he didn't have a right to stand his ground in this house that he had a right to be in. I realize it's somewhat duplicative, but it's the standard and that's what is allowed for. It doesn't say give
Right.
this or this.
Mr. Woodman?
No objection.
All right, so the next part we'll read. Collin Griffith was in you want dwelling or residence?
Residence is fine.
Was in a residence in which he had a right to be. He had no duty to retreat and had the right to stand his ground and use force, including deadly force, if he reasonably believed that such conduct was necessary to prevent imminent death or great bodily harm to himself.
That's correct, and B is not requested.
And the next section is not applicable, correct? Or are you asking for that? The use of deadly force is justifiable if defendant reasonably believed the force was necessary. I'm sorry. Yes, to prevent great bodily harm to himself while resisting any attempt to murder him, commit a forcible felony, or commit a felony upon him, or commit a felony upon her in a dwelling in which he was present. Are you asking for anything?
Well, and once again, Judge, it seems duplicative, but since it's not in the disjunctive, and it's entirely possible the jury could believe that Kathy was trying to murder Collin, or at least commit an aggravated battery upon him, I would request it.
Mr. Levine?
No objection.
Yes.
Right, so we'll read the use of deadly force is justifiable if Collin Griffith reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself while resisting any attempt to murder him or commit an aggravated battery upon him.
Yeah, can we also add aggravated assault?
Mr. Levine?
I don't object to the aggravated battery. What was the context, Your Honor, again, of the aggravated assault request by the defense?
They wanted to read, the use of deadly force is justifiable if Collin Griffith reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself while resisting any attempt to murder him or commit an aggravated battery or aggravated assault upon him.
No objection.
But the last paragraph you're not asking for.
But no, C,
Yes.
correct, I'm not asking for that.
Right. This next part about law enforcement and excessive force is not applicable, we agree.
I agree.
Now, in deciding whether Collin Griffith was justified in the use of deadly force, you must consider the circumstances at the time force was used. The danger need not have been actual, however, to justify the use of deadly force. The appearance of imminent danger must have been so real that the defendant actually believed the use of deadly force was necessary, moreover, to justify the use of deadly force. A reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force, was necessary. Right, this next portion about presumption of fear is not applicable, correct?
I don't think it's applicable, Judge.
And nor is the next portion of those A through D paragraphs, correct?
I agree.
Nothing about a presumption of intent to commit an unlawful act, agree?
I agree that is not applicable.
And we need to define residence, correct? But not dwelling, since we haven't chosen that.
Right, I think
Do you
residence.
agree,
is-
Mr. Levine?
No objection.
I do not need to define vehicle, correct?
Correct.
All right. And then there's this part. However, the use of deadly force is not justified if you find that Collin Griffith was attempting to committing or escaping after the commission of an applicable forcible felony. Am I getting that?
I'm not.
Yes, sir.
Okay.
Or kidnapping, correct?
Yes, sir.
Is there an objection?
No.
All right. However, the use of deadly force is not justified
I don't think that,
I don't know if that applies, does it, Mr. Levine?
No objection.
All right, so that whole section comes out. All right. And then I'm assuming you want prior threats or difficulties.
yes, please.
It's about if you find that Collin Griffith, who, because of prior threats or difficulties with Kathy Griffith, had reasonable grounds to believe that he was in danger of death or great bodily harm at the hands of Kathy Griffith. You may consider this fact in determining whether the actions of Collin Griffith were those of a reasonable person. If you find that at the time of the alleged first degree alleged first degree murder, should it also say the lessers?
As with the previous section in the same instruction, it could say first degree murder and all included lessers.
If you find that at the time of the alleged first degree murder or any lesser included offense, Collin Griffith knew that Kathy Griffith.
And Judge, I'm sorry to interrupt.
Yes.
The state's proposed instructions uses Catherine Griffith, so we should probably be consistent throughout.
All
I'm
right,
sorry.
I'll make that
Yep.
change
Got it.
before I finalize them. Thank you for that. Catherine Griffith had committed an act or acts of violence. You may consider that fact in determining whether Collin Griffith reasonably believed it was necessary for him to use deadly force. All right, as to these two reputations, are you asking for one or both?
Both, please.
Mr. Levine?
No objection.
All right. If you find that Catherine Griffith had a reputation of being a violent and dangerous person, and that her reputation was known to Collin Griffith, you may consider this fact in determining whether the actions of Collin Griffith were those of a reasonable person in dealing with an individual of that reputation. If you find that Catherine Griffith had a reputation of being a violent and dangerous person, you may consider this fact in determining whether she was the initial aggressor. Then, in considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Collin Griffith and Catherine Griffith. And that is it, correct?
Yes.
Any other comments, requests, suggestions with respect to justifiable use of deadly force?
No, sir.
All right.
And one quick question, is it my understanding that all the proposed subsections of justifying the use of deadly force have come from the standard jury instruction? There's no special request by the defense?
No special requests.
Everything, what was sent to me by Ms. Thornhill appeared to be directly copied from the Florida Bar website. So.
Yes, it was.
All right. Reading back up.
So then would excusable homicide follow that?
I agree. Are you talking about introduction of homicide?
No, that there was actually an excusable homicide instruction that was provided in the packet that the state,
Where is that?
I don't remember where it is.
The introduction to homicide portion, I'd have to scroll down to confirm, but
I didn't see that in the copy. I mean,
Your Honor.
excusable homicide is included in introduction to homicide.
But it doesn't give the explanation of what the circumstances are under which it would be excusable.
It was a complete instruction. I have the killing of a human being is excusable and therefore lawful under any one of the following three circumstances: when the killing is committed by accident or misfortune, in doing any lawful act by lawful means with usual ordinary caution without any unlawful intent, or two, when the killing occurs by accident and misfortune in a heat of passion, upon any sudden and sufficient provocation, or three, same thing, if a dangerous weapon is not used and the killing is not done in a cruel and unusual manner. Is that what you were referring to?
Yeah, that's what I'm requesting, and maybe it just is
I
part
think what
of
it is-
introduction to homicide, it just,
I think what it was is, because the standard instruction has the two sections, justifiable and excusable, and they're all caps in the standard instruction, and probably what happened is
Just second page.
went to a second page, but that's
Got
in,
it.
that's in there. All right. All right, after self-defense, are there any aggravator instructions that need to be given for weapons or anything like that? I didn't see any.
Your Honor, I think in the verdict form, there's special findings, and you're right, there should be an aggravator as it pertains to the knife and the weapon, but I don't believe that I remember to include it.
That would be aggravation by carrying, displaying, using, threatening to use, attempting to use a weapon. And was that charged in the indictment?
Yes, sir.
Yes. Sure.
Just to count one, I believe.
yes.
So that is 3.3A.
I'm sorry?
That's 3.3A. Do you object to that instruction being given?
No.
All right, let's hammer that one out real quick. All right, so that will read it'll be aggravation of, now, Mr. Levine, I've had this discussion with, well, he's a juvenile, so I think it is appropriate in this case. So it will be aggravation of first degree murder, second degree murder, and it does apply to manslaughter,
Yes, sir.
correct? Because it's a level enhancement, correct, not amendment.
Correct.
So it does not apply to first degree murder. I don't think that prosecutors take a different I mean, there's,
As it
it's a
pertains,
capital crime, so I mean, you can't.
Right, you
really
can't enhance it.
And on my verdict form, if I remember correctly, I don't have a special finding as it pertains to first-degree murder.
So it should be aggravation of second-degree murder and or manslaughter, correct?
That's acceptable.
You agree, Ms. Thornhill?
Yes.
By carrying, displaying, using, threatening to use, or attempting to use a weapon. And then it will read, if you find that Collin Griffith committed second-degree murder or manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, or attempted to use a weapon, you should find him guilty of first-degree murder with a weapon, or second-degree murder second-degree murder with a weapon, or manslaughter with a weapon. Agreed?
Yes.
Yes.
I don't need to define firearm,
That is correct.
and then I'll define weapon. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or to any other object. Do I need to do any other object?
No, I think it's,
Pretty clear.
yeah, we're
Do you
dealing
agree,
with the knife.
Mr. Levine?
I agree.
All right. Then the final paragraph, so I'll take out the one as well, so it will just be one sentence. Then the final paragraph, if you find that Collin Griffith committed second-degree murder or manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a weapon, then you should find him guilty only of second-degree murder or manslaughter. Correct?
Yes.
Yes.
All right. Now, there is no instruction on the issue related to juveniles. It's just a verdict form issue, correct, with the findings of actually killed, intended to kill, or attempted to kill, correct?
Yes, I agree.
All right, so that will take us then to 3.7, plea of not guilty, reasonable doubt, proof. This is the new standard instruction, I believe, correct?
That I don't know.
Well, it may not be, and I thought, because I've been giving this instruction by memory now for probably 15 years, but I never noticed until recently that first sentence of what a reasonable doubt is not. I never remembered it saying proof beyond a reasonable doubt does not mean proof beyond all doubt. I thought it just started with
A reasonable doubt
doubt is not a mere possible doubt. So I think this is new. Any objection?
No.
All right. And I am assuming, Mr. Levine, that that is pulled from the most current version on the website.
That was my intent, Your Honor.
All right, let me look, just to be doubly sure.
In my office, I wouldn't say it was necessarily pulled from the website, but pulled from our computer that is supposed to be the most up-to-date jury instructions originating from the website.
And that, it's in there, it's on the website, that does appear to be new standard language. Oh yes, it was amended May 2024. All right. Any Any objection to reasonable doubt?
No.
3.9, weighing the evidence. As to the, this appears to be standard, as to the factors for consideration 1 through 5 are always given. Do we need money or preferred treatment?
I don't believe so, Judge.
Mr. Levine,
I agree.
pressure or threat?
I don't believe that's applicable here.
Mr. Levine?
I agree.
I will give inconsistent statements. Is that agreed?
Sure.
Mr. Levine, you agree?
Oh, yes, Your Honor.
There's no felony or misdemeanor conviction, correct?
Correct.
And no reputation for truthfulness, correct?
Correct.
Do you agree, Mr. Levine?
I agree.
All right, so I'll renumber inconsistent statements as number 6. All right, the rest is standard, including expert witnesses. I will remove the defendant becoming a witness,
Yes, please.
and the rest appears appropriate. Agreed?
Yes.
Yes.
Do you want me to give 3.9A defendant not testifying?
Yes, please.
And am I giving 3.9B defendant statements?
Yes, please.
All right. Rules for deliberation appears to be standard. Is there any objection?
No objection.
Three point one, cautionary instruction is standard. Any objection?
No objection.
3.12, verdict.
I would object, if I thought it would do any good, to, you don't have to be unanimous on the premeditation or the felony murder. But I don't think I have.
You're making a record preservation objection?
Yes, I am making a record for preservation purposes.
Do you wish to make any argument?
Just that I think that the unanimity requirement should apply to the different theories that the state has put forth as to first-degree murder. I think that the instruction should be, your verdict must be unanimous either as to premeditation or unanimous as to felony murder.
Any response, Mr. Levine?
No, Your Honor, I would ask that you instruct the jury on the standard jury instruction.
The law, as I understand, has not changed, and that under Florida law, they do not have to be unanimous as to the type of first-degree murder, only that it be one or the other. I think this should go before the paragraph above it.
Yes, yes, it should.
Do you agree, Mr. Levine, that the last paragraph should go about the second to last paragraph?
Wherever it's supposed to go, Your Honor.
Okay. All right, so that's where I'm going to put it, and you agree with that?
That's fine.
We'll talk about the verdict form in just a second. Single defendant, multiple counts, I'm taking out or information in the title. But that appears to be standard and includes the caveat for legally interlocking counts. Any objection?
No objection.
That takes us to legally interlocking counts. Now, if I remember correctly, the last paragraph is is not standard, but it's something that has been used before, so this is sort of a special instruction, correct, Mr. Levine?
If I remember correctly, yes. I believe in these cases, maybe even Your Honor proposed it or gave the parties an option, and it seemed to make good sense and describe everything clearly and accurately. If the defense has any objection to something, I don't object to if they want something taken out. That's beyond the standard.
So Ms. Thornhill, the first two paragraphs appear to be standard and accurate. That last paragraph reads, however, the alternative crime of first-degree premeditated murder charged in count 1 is not linked to any other count in the indictment. A finding of guilty or not guilty as to count 2 must not affect your verdict as to the first-degree premeditated murder charged in count 1.
I think that's an accurate statement of the law. I don't have an objection to it being read, even though it's not part of the standard instruction. It might actually help them figure things out, that they actually notice that one is felony murder and one is premeditated murder.
So as to the rest of that instruction, any objections?
No.
All right. And that takes us to 3.13, submitting case to jury, which is standard. Is there any objection?
No objection.
And then the instructional discharge.
No objection.
All right, are there any other, before we talk about the verdict form, any other standard or special instructions requested by the state,
No, Your Honor.
by the defense?
I'm sorry, hold on. I'm sorry, Judge, what was
Any
it?
other standard or special instructions requested?
No.
All right. Let's take a look at the verdict form. Here is the verdict. All right. And so as to count 1, the first choice is for first-degree murder as charged in the indictment. Second choice, the defendant is guilty of second-degree murder, a lesser included offense. And under that, the further findings, and then manslaughter, which does not have the further findings. So my thought is we separate the verdict form into guilt findings and then special findings separately, since it would become repetitive if after second-degree murder and manslaughter, they're the same section of special findings. Does that sound fair, Mr. Levine?
It does, Your Honor, and I would ask that you add the language under manslaughter that's there for second-degree murder, the special findings. It was
Display.
I didn't put it on there as an oversight.
I think also the finding as to actually killing, well, you've only proposed that they be asked about actually killing Captain Griffith. You don't feel you need any of the attempted to kill or intended to kill language.
Yeah, by operation of the facts of this case, I'm okay with it just saying actually killed.
That's fine.
Okay,
But I,
go ahead.
because he is a juvenile, and that's what those special findings pertain to, would you put it under after the guilt findings, then do that as a further finding? That's what
Yes,
you were
it would.
indicating.
So
Okay.
we would basically have count 1 and count 2. It would be count 1 in order, first-degree murder, second-degree murder, manslaughter, not guilty. And then count 2, kidnapping, false imprisonment, not guilty. Then special finding, question 1, if you found the defendant guilty of first-degree murder or second-degree murder, You must answer the following question. The defendant actually killed Kathy Griffith? Yes, no. And I explained when I'm going over the verdict form that those also have to be beyond a reasonable doubt and unanimous findings. And then, so that's special finding 1. Special finding 2, if you found the defendant guilty of second-degree murder or manslaughter, you must answer the following question. The defendant carried, displayed, etc. Yes or no?
That makes a lot of sense.
Mr. Levine?
Yes, sir.
All right. So I'm not going to pound through that here while you're sitting in front of me. I'll just correct it
Thank you.
and email everything to you all this afternoon so you have it. And if you see any errors today, it's invariably, as I'm reading the instructions, I see one, but I would ask that you review them, and if you see any typos or other errors, to just alert me by email so they can be changed before they're printed tomorrow morning.
Yes, sir.
Is there anything else we need to take up this afternoon?
No, Your Honor.
I don't believe so.
All right. And I told the jury they'd probably be going to deliberate around lunch. Are you anticipating all-day arguments?
No, Your Honor, I think they will be deliberating by lunch.
I agree.
All right, everybody enjoy the rest of your day. I'll see you at 8:30.
Thank you.
All right.
Yes, I'm back. Snickers. All right, guys. If you're new and just joining in, welcome to Pink Dino Media. And we're going to bring you the latest updates. So here's a morning session recap. The defense continued presenting case today, which they did present their case today, focusing on Catherine's background and history. Key testimony from this morning included Catherine had been Baker Act multiple times, meaning she had been placed under involuntary psychiatric care. Testimony described Catherine as having a temper, and her mother stated she had been known to be violent. It was revealed through testimony that Catherine had attempted suicide 6 times. There were mentions of Catherine being estranged from multiple family members. Now, the state cross-examined Catherine's mother, and here are some questions and points that they raised. 1 second, guys. Sorry about that. So after Susan testified, the defense rested its case in chief, and Collin chose not to testify in his own defense. And the defense confirmed that competency will not be used as a part of their strategy. The court is now working with attorneys to finalize the jury instruction as the trials move forward. What are your thoughts on today's testimony? Let's discuss it in chat. If you are replaying, please put your comments in. We appreciate hearing what everybody's thoughts are. Also, thank you for tuning in today, and we will be back for closing arguments. Make sure that you hit the notification bell so you don't miss any updates. We'll see you next time. Take care.